We are now on the record for Wednesday morning, February 23rd, 2022, civil docket. And Mr. Guerra.
Good morning, Your Honor. Number 11 on your docket. It's a friendly suit. We got word this morning that the ad litem is not going to be able to make it. She has a family emergency, and we'd like a very short turnaround, Your Honor. This is an old friendly suit, and we'd like to try to get this taken care of and the money in the registry of the court for these children.
Okay. The soonest that I can do is March 9th at 9:30.
That's perfectly fine with me, Your Honor.
Okay. Anything else?
That is all. May be excused.
You certainly may, sir. Thank you.
Thank you, Your Honor.
Okay, Mr. Jackson.
Hi, Judge. How you doing this morning?
Good morning, sir. Doing well.
Great to see you, Judge. Always a pleasure.
Likewise.
We have number 27 on today's docket, Your Honor. It's just for an announcement. I believe Mr. Juan Alvarez is on the other side.
Okay, F1314-20-9 in the matter of the marriage of Carey Villarreal, Karey, and Mario Flores.
That is correct, Your Honor.
I saw that Ms. Canales was on. I don't know if she's making an announcement on behalf of Mr. Alvarez.
Oh,
Yes,
see.
I am. Yes, I am, Your Honor.
Okay, and what is the announcement, counselors?
Your Honor, we're just respectfully requesting a 30-day reset. We are almost done with this case. It's just a few details that we need to put in the final decree of divorce. Mr. Alvarez and I feel very confident can work out those details. That way we won't take up any of the court's time. We're just requesting 30 days, Judge.
Okay, anything to add?
No, Your Honor.
Okay, the soonest that I have that fits that time frame is April 11th at 9:30.
Thank you, Your Honor. And if we have a decree prior to that, can we submit it to the court?
Do they have children?
Yes, you do.
Okay, just contact Ms. Rivera and we'll try to squeeze you in sooner.
Okay, that'll be fine, Judge. We'll work it out.
Okay, thank
Judge,
you.
you have a wonderful day. It's always a pleasure being before my favorite court. And that's on the
Likewise.
record.
Thank you, Mr. Jackson. We'll see.
You have a wonderful day, Judge. Bye-bye.
Thank you. Ms. Canales, do you have another case?
I'm actually an ad litem on a case, Your Honor, with Joe Richard Flores and Savannah Gonzalez.
Okay, go ahead.
I don't know what number it is, Your Honor.
All right, is Mr. Flores, are you present?
I believe he was in another court. I can just wait, Your Honor.
Okay, that's fine. All right, Mr.
Thank you, Judge.
McClellan?
Good morning, Your Honor. I have number 24 on your docket.
Okay. CO173652-I, Raul Martinez et al. Versus Southern Vanguard Insurance Company et al.
Morning, Your Honor. Tina Danek for underwriters.
Yes, Your Honor, this is a status hearing. I think the last time we had Ms. Danish and I, the court had reset us and I guess suggested mediation. We've been talking a little bit about maybe resolving the case, and then there's another party, Southern Vanguard, that we're hopefully going to finish and settle with them as well. So I didn't know if Ms. Danish wanted to talk a little bit about it, or just needed some more time, or if we
will not be able to resolve the case. I think I sent you an email regarding that.
Oh, okay.
Okay, so if you're not going to be able to resolve the case, then is it ready for you all to go to trial or what?
We haven't gone to mediation, Your Honor. That's, I guess, the next step. But I know the court wants us to go to mediation before.
Yes, that's a requirement.
Um,
But if you're ready to go to trial, you can file a DCC and follow the deadlines, and the deadline in there's a deadline for mediation there.
Okay, Your Honor. That's all I have before this honorable court, Your Honor.
Your Honor, underwriters have filed a motion for reconsideration and would like to set that for hearing. Can we get a date on that?
Did you file an order setting hearing?
Yes.
Okay, I'll have that forwarded to my court coordinator's queue and they'll get it set for you.
Okay, thank you very much.
Yes,
Thank you, Your Honor. Have a good day.
thank you. Likewise. All right, Mr. Hinojosa?
Yes, Judge, I have two on your docket. The first one is number 21 on your docket.
F 3808-18-9 in the matter of the marriage of Blanca Garcia Gomez and Rene Guillen.
Judge Avelino Hinojosa, Rene Guillen. I received the order signed by Pete Espinosa this morning, Your Honor, and we e-filed it this morning. If the court can sign, have the court can sign the one that's signed by myself and Mr. Espinosa, Judge. That should resolve the case.
Okay, I'll ask Ms. Rivera to have that forwarded from the clerk and sent to my queue, and I'll sign off on that one.
Thank you, Judge. Also, number 29 is, I basically just like to know the status of number 29, Judge. Mr. Nittler was supposed to obtain counsel, and I don't know if he has or not.
Okay, that's F 0069-22-9 in the matter of the marriage of Amy Nittler and Stephen Nittler. Mr. Nittler, are you present?
I'm here.
Okay, were you able to secure counsel, sir?
I have, but I have my final consultation tomorrow with Ms. Klein.
Okay. When was that second TRO set to expire, Mr. Hinojosa?
Today, Judge. Today is the hearing.
Okay, so Mr. Nittler, when will you know after? How soon after will you know if Ms. Klein is accepting you as a client?
Tomorrow, ma'am.
Okay, then what I'm gonna do is just come back for a quick announcement on March the 9th. It'll be extended until that time. And it'll have to be quick because I am set for a bench trial on that date.
Okay.
Very
So
well,
I won't
Judge.
hear anything contested. I'll just need to know whether Ms. Klein is coming on or not.
Very well, Judge. I'll submit the order extending for March 9th at 9:30 a.m., Your Honor.
Yes.
Thank
Okay,
you. Thank you.
all right, you're excused. Okay, Mr. Patino?
Morning, Judge. I have number 15 on the court's civil docket. Judge, this is a quick prove up of relinquishment of parental rights. We filed a proposed order, I believe yesterday, Judge, on this, and several documents.
Okay, I'm sorry, what number?
15, Judge, 15.
Oh, 15. I heard 50. I go, my docket doesn't go past that number. Okay,
Yep, that'll be a long day for you, Judge.
yeah. It wouldn't have been the first though. Okay, F-4216-21-9 in the interest of a minor child. Okay. Let me go ahead. And your client is who?
My client is Leah Michelle Jara, Jara, Judge.
Okay. Okay, give me a moment. Okay, Ms. Hada, please raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay, you may lower your hand, Mr. Patino.
Thank you, Your Honor. I'd like to ask the court to take judicial notice of all documents on file in this case.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the father's affidavit for voluntary relinquishment of parental rights. Give me one moment. Where he has also waived service. All right, before we move on, what is the reason for the termination?
Your Honor, the father has basically not wanted to have the child as his son, all the responsibility associated with that, Judge. And he has not been in his life at all since the child was born, not providing any type of support for the child. And so Ms. Hara would like to, move on from this.
How old is the child?
He is 1 year,
And about to be 3 months next week.
1 year, 3 months, Judge.
Okay. So, the intent of the legislature, of course, is to provide a parent every opportunity to be able to forge a relationship with the child. And although this child is a year old, I'm hesitant because of the fact that there hasn't been a chance to provide this biological father an opportunity to be in the child's life. And I'm not sure what the circumstances are that surround this, other than the fact that he probably doesn't want to pay child support. And although we know, and you know, that paying child support is not a condition of having visitation with a child. So visits with a child occur whether or not the person provides any child support. Was there ever an establishment of parental rights, such as, was a SAPSR ever filed?
No, Judge.
Okay, so a SAPSR was never filed setting forth anything with respect to visitation or child support to provide the biological father an opportunity to abide by an order. Is that correct?
That is correct, Judge. And the child's father signed this, Judge, on September the 22nd. And it's been well over 60 days. I think the legislature requested 60 days in order for him to revoke it if he wanted to. And he has not, Judge.
No, I understand that, but I've had cases in the past when I practiced that well over 60 days. We're talking 6 years or even longer sometimes, when a parent has changed their mind to come back. And I understand, but this child is only a year old. So I don't know what the circumstances were that caused them to not, for him not to be in his life. I mean, there's a lot more here. Like, I don't know, was there a history? Were they together as husband? I mean, obviously they weren't married, but did they have a relationship? How long did they have that relationship for? Was he violent? Is there somebody that she's with now that's looking to adopt the child? Is it just because he hasn't stepped up in the last year that she's wanting this? I mean, a termination of parental rights, even when they're trying to discard their rights, so in my opinion, carelessly, it's not something that should be taken very lightly. So what I'm going to do is I'm going to have you file an order for an ad litem to be appointed to this case. And I'm going to have, and that ad litem will have a background in this, and will know very well what questions it is that I'm going to be looking at to see whether it is in the child's best interest. So I understand that this man has not stepped up in the last year, but what I would tell you is I need to know something that will show me that he has no intent of stepping up in the future, other than a signing of a voluntary relinquishment of parental rights.
Your Honor, I don't know if this helps, but while she was pregnant, Judge, he basically, I don't want to say forced her, or he basically demanded that she have an abortion on this case, Judge.
And I understand that. I mean, and I'm aware that that does happen, and I'm not saying I mean, people say things in the heat of the moment too. You know what I mean? And I'm not trying, before I terminate this man's rights, I need to know that I'm doing it for the best interest of the child. I need to know that, there's no way that this man's going to want to come back. And if he comes back later and has regret, well, I need to know that I'm comfortable in terminating those rights. So go ahead and file that order appointing ad litem today so I can get that done and give you a quick reset. That ad litem just needs to do some very minimal checking.
Yes, Judge.
Okay,
Thank you so much, Judge.
all right, thank you.
Can we be excused, Judge?
Yes,
Have a good Judge.
thank you. Ms. Williamson?
Good morning, Your Honor. I have several. The first one I have is just it's a finalization. We've already submitted the order. Mr. Juan Ramos is on the other side, and he texted me a little while ago and said he's not going to be available. He's in another court in a contested matter, but if I could go forward and prove it up. And I
Okay,
have no objection.
all right, and that's,
Number
I've got
7
on-
on your docket.
all right, F4066-21-9 in the matter of the marriage of Sasha Estrada and Noe Estrada. Is Miss Estrada present?
Yes.
Your Honor, I know she is logged on, and my client is here in my office.
Okay, Miss Estrada, can you hear me?
Yes, ma'am, I'm here. Can you hear me?
Yes, okay, Miss Estrada, Mr. Estrada, please raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Miss Estrada, yes or no?
Yes.
And Mr. Estrada, yes or no?
Yes.
Okay, thank you. You may lower your hands. Go ahead, Miss Williamson.
Thank you, Your Honor. Mr. Estrada, can I have your complete name?
Noe Estrada?
And is it true and correct that you are married to Sasha Estrada?
Yes.
And you and Miss Estrada have one child of this marriage, correct?
Yes.
And to your knowledge, your wife is not expecting at this time?
No.
Other than the child listed on the divorce decree, did you and your wife adopt any other children?
No.
All right. And have you and your wife entered into a final agreement concerning the divorce, conservatorship, and property?
Yes.
And does this agreement include that you and your wife are to have joint managing conservatorship of the minor child?
Yes.
And that the primary managing conservator will be mom, and the child is to reside within Hidalgo County?
Yes.
You and mom are to continue to alternate weeks
Yes.
with the child, and the exchange is every Sunday at 6 p.m., correct?
Yes.
And you are to continue to provide medical and dental insurance on behalf of your daughter. Any uninsured medical expenses are to be split equally between the parties, correct?
Yes.
And at this time, each of you is to support the child while in your possession, and no child support shall be due, correct?
Yes.
All right. And do you feel that those provisions as to your daughter are in her best interest?
Yes.
And are you asking the court as to the provisions to your daughter that they be approved?
Yes.
Now, during the course of, or as far as the property, you are asking that each of you be awarded that property in your possession at this time, correct?
Yes.
And that includes, she gets all her accounts, any belongings that are in her possession at this time.
Yes.
And you are asking for the same, correct?
Yes.
That your belongings.
Yes.
Okay, and that includes a home that you had at 802 East Fanning Avenue in Alamo.
Yes.
And each of you is going to be responsible for any and all debts in your name alone, correct?
Yes.
And specifically, you'll be responsible for the mortgage on Fanning Avenue.
Yes.
Now, there's some debts listed on this divorce decree. Your wife is to be responsible for a Wells Fargo ending in 00001. Is that correct?
Yes.
And for a Nelnet debt student loan that is in her name alone, correct?
Yes.
And you're to be responsible for your mortgage, correct?
Yes.
Capital One,
Yes.
Wells Fargo ending in 2377,
Yes.
and a Wells Fargo account ending in 0001,
Yes.
and a Chase ending in 0667.
Yes.
Okay. And as far as the division of the marital estate, do you feel that that's an equitable division?
Yes.
Are you asking this court to approve it?
Yes.
All right. Now, let me go back to your daughter. You and your wife also agreed that each of you is going to be able to claim the child for tax purposes on alternating years, correct?
Yes.
Mom is to claim the child on all odd years. You're to claim the child on all even years, correct?
Yes.
All right. And is there any chance at this time, Mr. Estrada, of reconciliation?
No.
Are you asking for a divorce?
Yes.
in this divorce decree, your wife is also asking for a name change. You understand that?
Yes.
Okay. No further questions, Your Honor.
Okay, do you have any questions of Ms. Estrada?
Yes, Your Honor.
Okay, go ahead.
Thank you. Ms. Estrada, can I have your complete name?
Sasha Maria Estrada.
And
I'm sorry, hold on. You need to speak up, okay?
It's Sasha Maria Estrada.
Ms. Estrada, did you hear all the questions I asked your husband?
Yes, ma'am, I did.
And are you in agreement with the terms as read into the record?
Yes, ma'am.
And did you have an opportunity to review the divorce decree prepared in your case?
Yes, ma'am, I did.
And did you sign that divorce decree after reviewing it with your attorney?
Yes, yesterday.
Okay, and are you asking also for a divorce?
Correct. Yes, ma'am.
And do you feel that this is a fair and equitable division of the marital estate?
Yes, ma'am.
And the provisions as to your daughter, do you feel that they're in the child's best interest?
Yes, ma'am.
And ma'am, is it true and correct, you are asking for a name change, correct?
Correct.
And that you now be known as Sasha Marie Rodriguez?
Correct. My maiden name.
Okay. And you too are asking for a divorce?
Correct.
I have no further questions, Your Honor.
Okay, the court is taking judicial notice of all the documents in the court's file. And I commend both of you for coming up with an agreement that centers around your children. And so I am granting your divorce today. I'm granting your name change and the relief as requested and testified to on the record. And that will be set forth in further detail in the order. You said that order was already e-filed?
Yes, it has been, Your Honor.
Okay, I'll ask for that to be forwarded to my queue for my signature.
Thank you, Your Honor. I have nothing further on this case. I do have two other cases, one with Mr. Sahari, who has also his hand up, so I don't know if that's for us.
Okay. All right, so Mr. Estrada and Ms. Rodriguez, you are both excused.
Thank you.
Thank you.
Okay, thank you. All right, and what number is that, Ms. Williamson?
It is number 1 on your docket, Your Honor.
Okay, F1355-15-9 in the matter of the marriage of Armando Solis and Maria Teresa Garcia.
Good morning, Your Honor. James Sadi on behalf of Mr. Armando Solis.
And good morning, Your Honor. Lucy Williamson here on behalf of the wife, Maria Teresa Solis.
Okay, and what is the announcement, counselors?
Judge, we are set for final hearing. Now, Ms. Williamson and I had spoken about possibly informally mediating the case. I know that the case was mediated very early on before I was retained as counsel. And I don't know if Ms. Williamson is still open to that or not. If she is, then I would request a reset of the final hearing. But if she's not in agreement with an informal mediation, then still I would still request a little bit of time in order to prepare for a contested final hearing, Judge.
Your Honor, the only thing I asked, if it would be possible for us to break out to a separate breakout room, we might be able to resolve this case. There is no more issues on this matter.
Okay, so let me ask you, because I'm going back and looking at the docket sheet. Are we still working on a divorce from 2015, or did they just style it wrong?
No, Your Honor, you are correct. And in fact, out of the 4 children, 2 of them have emancipated already. And for several years, the situation was the children have changed considerably. I think the parties have probably grown up a lot. And I think it's something that could be resolved if Mr. Sahadi and I could have maybe even 10 minutes just in a breakout room. I think it will definitely be something that we can work out.
Okay.
That's fine, Judge.
And then I'll go ahead and do that because, and you all know that I don't have, if you all forego a jury, I mean, what are the issues to deal with custody or with the property?
I think it mainly has to come down to the property, Judge.
Right.
Okay. Well, you all know that I'm all for bench trial. So,
yes,
you know, let me know if I can be of any help because I'm sure Have they reconciled in these 7 years going back and forth? Like, have they gotten back together and then?
Never.
They have not, Judge.
Okay. Yeah. Okay, well, both of you know me well enough, so.
Yes, Your Honor.
Okay, let me go ahead and put both of you in a breakout room right now. I'm gonna open it.
Okay, thank you, Your
Okay,
Honor.
go ahead. Okay, Mr. Peña?
Good morning, Your Honor. I'm set for number 12 on your docket. It's a friendly suit. I have Mr. Roger Garcia for the defendant. We have spoken with the ad litem, Ms. Lucy Thompson. The situation is that my client, for some odd reason, she knew about today's hearing, is unable to be in attendance. And so I'm asking the court for a short reset. I've spoken, or my office has spoken with Ms. Thompson's office, and she's okay with it. And I believe Mr. Garcia is as well, Your Honor.
Okay, let me see real quick.
For the record, Your Honor, good morning. Rogelio Garcia representing defendant Esperanza Romo, and what Mr. Peña has announced to the court, I'm in agreement with.
Okay, let's go ahead and, would next Wednesday work?
I hope so, Your Honor. I'll try and get my client in here by next
Okay.
Wednesday.
Then we'll do March 2nd at 9:30 and just get on like you did today and do the raise your hand because we have a longer docket on that day, and that way I can take y'all up first.
Thank you, Your Honor. May we be excused?
Yes.
Yes, Your Honor. Thank you, Judge. You have a good day. Thank you.
Likewise.
Thank you.
Okay, Mr. Gasso?
Good morning, Your Honor. This is item number 17 on the docket.
CL 21-28-57-I, La Imperial USA versus Carla, Karla, Din, DIN, International et al.
Thank you, Your Honor. This is a motion for default judgment against several defendants, specifically Alicia Dean, aka Carla Dean, aka Carla Dean International, and Edward Dean. So I do have a representative from the plaintiff present, but if we can just proceed by taking judicial notice of the documents attached to the motion for default judgment.
Okay, the court will take judicial notice of the documents in the court's file, and then you need Ms. Din. She needs to be called out, and you need Alicia Din called out.
Yes.
Carla, Edward, I'm
Mhm.
sorry, go ahead.
So it's Alicia Din, aka Carla Din, aka Carla Din, with a C and with a K.
Okay.
And then
Okay.
Carla Din International LLC and Edward Din.
Okay, so is anybody here for representing Carla Din International LLC or in Alicia Din, also known as Carla Din, also known as Carla Din with a C, or Edward Din or Isela Tenorio Salinas? All right. There being no, go ahead, no response. I'm taking judicial notice of the documents in the court's file, specifically that they were all served properly. Go ahead.
Thank you, Your Honor. Attached as exhibits 1 through 3 are copies of the citations that were served on Alicia Din, Carla Din International LLC, and Edward Din. More than 10 days have transpired since they have been on file with the county clerk's office, and more than 20 days have passed. The answer was due back in, these were served in August and September, so the answer was due around October, November. We provided a no military status affidavit for Alicia Din and for Edward Din, and also a certificate of last known address for defendants. The damages as alleged in plaintiff's petition are liquidated and proved by an instrument in writing attached as Exhibit 6, in which the plaintiff seeks liquidated damages in the amount of $92,526. And we are seeking a judgment where the defendants are held jointly and severally liable for this amount. And we do have Mr. Soto. He is the representative of Mr. Efren Soto Morfin present with us. I don't think we need his testimony, but he's present if the court should have any questions.
Okay. So there is no answer on file. The court finds that all the requisites, statutory requisites were met, and is granting the default judgment against each defendant today, and granting the relief as set forth on the record and set forth in further detail in, I don't see that an order has been filed.
No, Your Honor, we'll get an order on file here in the next couple minutes.
Okay, well, as soon as it's submitted, I'll go ahead and have that forwarded to my queue.
Thank you, Your Honor. Nothing further. Can I be excused?
You certainly may.
Thank you. Have a good morning.
Thank you. Okay, Mr. Cisneros?
Good morning, Your Honor. We're number 19 on your docket. Ms. Barba is opposing counsel. She's present in this
Okay.
room as well.
CL 21-1113-I, Kimberly Herrera versus Stripes.
Correct, Judge. I represent 7-Eleven, Stripes, Sunoco Wholesale. They've been non-suited or they've been dismissed or dropped from the lawsuit, Judge. Today, we were set for hearing on 2 of defendants' motions. One of them was an MSJ, which resulted in an amended petition, and the improper parties were dismissed by Ms. Barba's firm. So that motion is moot, Judge. We're asking you to take us off the record, off your docket. And then we had also filed a motion or a Dauber challenge. It's not timely at this time, Judge. I'm asking that it be passed for now, and I don't think there's any opposition. We did file a Rule 11 this morning, and we filed notice to the court yesterday that we were going to be passing those defendants' motions that were set for today.
Okay, Ms. Barba?
Yes, good morning, Your Honor. Bertha Barba here for the plaintiff, and that is correct what Mr. Cisneros has just told the court.
Okay, then that's fine. If you need that Dauber motion heard in the future, just file an order resetting hearing.
Will do, Your Honor. It's my first time before you, Judge. It's very nice meeting you, and I'm sure I'll be seeing you again.
Okay, likewise, sir. Thank you.
Yes, nothing further, Judge. May I be excused?
Yes, you certainly
Thank you. Have a good day.
Have a good day.
May I be excused, Your Honor?
Yes, sir.
Thank you, Judge.
you. Mr. Salinas, can you hear me? Attorney Kennedy Salinas? Okay. All right, Ms. Harlian?
Good morning, Judge. I'm here on number 22 on your docket.
All right, F 3928-21-9 in re Patricio Fidencio Rodriguez.
Good morning, Judge. Stephanie Harlan with Texas Rio Grande Legal Aid, and I represent the petitioner, Pat Rodriguez, who's here.
Okay, Ms. Rodriguez, okay. There you go. Can you unmute yourself, please?
Yes, hello.
Hi. Okay, can you raise your right hand? Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
All right, go ahead.
Thank you, Your Honor. Can you please state your full name, your current legal name?
Patricio Fidencio Rodriguez.
And are you over the age of 18?
Yes.
Are you asking the court to change your name to avoid any criminal prosecution?
No.
What about to avoid paying debts?
No.
And what is your current home address?
301 South Inspiration Road, Mission, Texas, 78572, apartment 1114.
And what is the sex you were assigned at birth?
Male.
What is your date of birth?
October 28th, 1998.
And where were you born?
McAllen, Texas.
And you don't have a driver's license, is that correct?
I do not.
But you have a Texas state ID?
Yes, I do.
And you included the full number of your ID on the proposed order that we filed, correct?
Correct.
Is this the only ID you've had in the last 10 years?
Yes.
And are the last 4 of your social 7457?
Yes.
And you did include your full social in the proposed order we filed, correct?
Correct.
And you don't have an FBI number or a SID number assigned to you, is that correct?
Correct.
Have you ever been charged with a Class A or B misdemeanor or a felony?
No,
Have you ever been convicted of a felony?
no,
Are you required to register as a sex offender?
no.
And when we filed your petition, did we also attach a copy of your fingerprints?
Yes,
And did you complete a DPS background check?
yes,
Do you believe that your name change is in your best interest or benefit and the interest of the public?
yes.
And what are you asking the court to change your name to?
Santana Fidencio Perales.
Nothing further, Your Honor. Okay, the court is taking judicial notice of all the documents in the court's file. And finds that you have met all the prerequisites and the statutory requirements and grants your name change. I will ask for the order that was filed yesterday to be forwarded to my queue.
Thank you, Your Honor. That's all I have in front of you today. Maybe be excused?
Yes, you certainly may.
Thank you.
Thank you. You're very welcome. Okay, Mr. Salinas, can you hear me? Attorney Kennedy Salinas.
Judge,
Good morning, sir.
good morning. How are you doing?
I'm
Judge,
doing
good
well,
seeing
thank
you.
Likewise. Okay, what number, sir?
It's number 30 of your docket, Your Honor, and we're set for a temporary orders hearing on this case that's been around for quite a while.
Okay, I have that on my docket for 11 a.m.
Yes,
Okay, so at 11, I'll call it.
okay.
All right, so you can come, in about half an hour, we should be there.
Mhm. Okay,
Okay.
Your Honor, I don't know you want to, I got another motion and he just filed it. I believe this morning my staff gave it to me, a motion for continuance. Mr. Munoz.
Okay, well, I'm not aware of that, but when he gets
Yeah,
on,
we're ready to proceed, yes. So we'll be here at 11:30 or what time?
no, at 11.
Okay, yes, we'll be here. Thank you.
All right, thank you. I'll recall you at that time.
Thank you so much.
Okay, Mr. Flores?
Good morning, Your Honor.
Good morning, sir. What number?
Number 28 on your docket.
Okay, F 3814-21-9, in the interest of a minor child. Is Ms.
Yes, Your-
Gonzalez present, or are you making the announcement for both of you?
I
Your
believe-
Honor, Christopher Castillo standing in for Ms. Gonzalez. She's actually in the bench trial on the 398.
Okay,
And I believe Melissa Canales, she's the attorney of the guardian ad litem for the child, Your Honor.
all right, and she is present, and what is the announcement?
Your Honor, that is hearing, since we have, I think Savannah was appointed by the court as attorney ad litem for the unknown father, and Melissa was appointed as a guardian ad litem. We'd like to, the mother of the child, Susan Eileen Cardona, she's presently incarcerated. Again, she was indicted on 3 counts, 2 second-degree felonies and 1 third-degree felony. She's scheduled for an arraignment this Friday in the 389th District Court, Your Honor. So she has several outstanding matters, and she also has a misdemeanor resisting arrest charge arising out of the same transaction. So we're ready to go. I would ask the court to set a final hearing to get this matter resolved.
Okay, anything to add, Mr. Castillo or Ms. Canales?
Nothing at this time, Your Honor.
Okay, so you
Your
want,
Honor,
go ahead, Ms. Canales.
I just wanted to say that I think it's in the best interest of the child to go ahead and finalize this case, Judge.
Okay, no problem. Then what we'll do is we'll come back on April the 13th. And we'll do that at 11 a.m.
That's for the final hearing. Is that correct?
Yes, final hearing.
Your Honor, I don't know, would the court need any other, like a social study or anything of that nature, or?
No, the ad litems that are appointed on this case have an extensive background in this area. And so I feel that I'm very comfortable in making a decision, just having them look at it. So I know that it's probably also limited financial resources. So I'm not going to require that.
Okay. That'll be fine, Your Honor.
Okay.
Thank you, Judge.
All right. Anything else?
Yes, I apologize. I believe he had called my case earlier. Unfortunately, I was in a probate hearing, so I just couldn't get to y'all.
That's fine. Don't worry about it.
Okay. Thank you, Judge.
All right. Thank you. Okay. Ms.
Thank
Canales,
you.
do you have anything
Thank you.
else?
No, Your Honor.
Okay. Mr. Castillo, anything else?
No, Your Honor, may be excused.
Yes. Thank you all so much.
Thank you,
Thank
Judge.
you, Judge.
Okay. Ms. Garza?
Yes, good morning, Your Honor. I'm here for case number 9 on your docket. I represent Mr. Ruben Cuellar.
Okay, F 4702-17-9 in the matter of the marriage of Lee Garcia Cuellar and Ruben Cuellar.
Good morning, Judge Sonny Palacios, Ms. Lee Sandra Garcia Cuellar.
Okay, and what is the announcement?
Judge, there's a preliminary, I have Ms. Garza, we could take up first and then approve up.
Go ahead, Ms. Garza.
Yes, Your Honor, I am requesting the court grant me permission to withdraw as attorney of record for respondent, Mr. Ruben Cuellar.
We have no objection, Judge.
All right, and is Mr. Cuellar present?
And I don't believe he is present.
Yes,
I notified him.
Yeah, he's on the line.
I'm here.
Okay, Your Honor, I notified him via certified mail and regular mail, and the certified mail was returned to me as undeliverable to his last known address. So I was not notified of his new address.
Okay. Then being no objection from opposing counsel, Ms. Garza, I'll grant your motion to withdraw.
Thank you, Your Honor.
Okay, and Mr. Palacios, you wanted to proceed?
Yes, Judge, Sonny Palacios, Ms. Lee Sandra Cuellar, she's present on screen, Judge.
All right, then let me have Ms. Cuellar and Mr. Cuellar raise their right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Ms. Cuellar, yes or no?
Yes.
Mr. Cuellar, yes or no?
Yes.
All right, go ahead. Lower your hands.
Ms. Cuellar, can you please state your name for the record?
Lee Sandra Garcia Cuellar.
Ms. Cuellar, have you been living in the state for 6 months period before filing and within the county of Hidalgo within 90 days before filing this decree divorce?
That is correct.
And are you currently married with Mr. Ruben Cuellar?
Yes.
And you, Mr. Ruben Cuellar, were married around on or about March 2002?
Yes, sir.
No, Mr. Cuellar, you need to let her answer and then he'll go ahead and ask you the
I'm
question.
sorry.
Okay, go ahead, Ms. Cuellar.
Yes, Mr. Palacios.
And you and Mr. Cuellar separated around June of 2012?
Correct.
Have you found this marriage to Mr. Ruben Cuellar insupportable because of discord conflict that destroys the legitimate ends of the marriage?
Correct.
Is there any reasonable expectation of a reconciliation?
No.
Do you have any children in the marriage?
Yes, sir.
And there's, if I'm not mistaken, 3 children?
Correct.
And they are all over the age of 18, is that correct?
No, sir. No, sir.
Okay, can you say which one is under the age of 18?
2 of them, Eliana Nina Cuellar, she is 17, will be turning 18 this July, and then Dominic James Cuellar. He is
And Caden is currently over the age of 18, is that correct?
over the age of 18. He is 20.
Um,
Caden Isaiah Cuellar. He is 20 years old.
Are you currently expecting any children?
No, sir.
Have you and Mr. Cuellar adopted any children or currently adopting any children?
No, sir.
Are there any court order relationships regarding the possession of the children or custody of the children?
I have custody of the children. Yes.
And that's by court order?
Yes.
Okay. And it's the same thing with child support?
Yes, sir.
And just once again, you and Mr. Cuellar have been separated since June 2012, is that correct?
Correct.
You and Mr. Cuellar did review a document called the Agreed Final Decree Divorce and Order for Conservatorship, is that correct?
Yes, sir.
And both of you have signed up that agreement?
That is correct.
I'll show you a document that we talked about. Did you sign that agreement after discussing with your attorney?
That is for me, sir, or was that for Ruben?
That's for you.
Yes, those are. Yeah.
And that is your signature, is correct? Is that correct? And do you recognize the second signature on that document?
Yes, that's Mr. Cuellar's.
Okay. Do you believe this agreement is fair and equitable to both parties in regarding the children?
Yes, sir.
And are you asking the court to approve this divorce?
Yes, sir.
The pass with this judge.
Okay, before we go on for you to Mr. Cuellar, so there's already a SAPSR in this case or what?
Say again, ma'am?
No, I'm asking Mr. Palacios.
No, Judge, it was
Because since she testified that by court order, so was there temporary orders in this?
Oh, no.
Judge, what she meant by court order is there is an agreement in this court order that has this, and they've been following it since 2012. This is an old case that we're trying to shut down or close it.
Okay, so there's not a SAPSR.
That's correct, Judge. There was just an old agreement that they were following, depending
Okay.
out of this case.
And in this situation right now with the two minor children that are remaining, are they going to, what kind of visitation are they having with dad, standard or?
Judge, this would be a JMC standard. They'll be living with mom, standard visitation for dad.
And what is child support set at? I'm not sure if I missed that.
The child support is as per the guidelines, but let me pull the information. I didn't bring my reading glasses. The child support is at $550 per month.
Beginning,
Judge, that was beginning December 1st, 2019, when this first was being circulated between the parties.
okay, so has he been paying that amount since then?
To our understanding, Judge, he should have been, according to the previous order, the temp orders.
I'm only asking because if not, what are we doing as far as arrears? Is there going to be a judgment that's taking, or is she foregoing any past child support amounts that are due to her?
Judge, we don't see any arrears, and she hasn't complained of any arrears.
Okay, Ms. Cuellar, so has Mr. Cuellar been paying you child support since 2019?
Correct. And there's already an arrears case set up with the OIG, and I currently have an account with that set up as well.
Okay, so if she has an account with the OAG, that means that she has a SAPSR.
No, I'm sorry, with the child support. I mean, whatever it's called, the Attorney General's.
Yes, I know what it is. But what I'm
Sorry.
saying is if you have a case with the Office of the Attorney General and it hasn't been set up through your attorney's office, and that means that you have a SAPSR. So if you have a SAPSR, then you have to have a motion for consolidation to consolidate on file. So first you all need to figure out how is it that she has a case open with the Office of the Attorney General where she has been receiving child support and there's an arrears?
Judge, we've been seeing something, we've actually looked for that in the past, and we're looking at it right now. There may be an open case at the OAGs, but we do not see a SAPster out of that court, out of that.
Okay, but if there has to be. If she has a case with the AG's office, there has to be. Have you asked her for her OAG number so that you can contact them?
Judge, we'll contact them. Judge, I guess what we can do is if we can, please make this for 1 week and we can get that information. But we'll contact them directly by phone because it's not something we can see online.
Hold on. What is your name under on that OAG case, Ms. Cuellar? Is it under Garcia Cuellar or Cuellar?
Garcia Cuellar. And I have my number if you want it, if you would like.
Okay, the thing is that, go ahead and put your case number on the record. What's your OAG number?
You know what, I have to log in. I have my SIN number, but I don't know
Your
not
Honor,
really.
Go ahead.
Judge, there is a CW case and it's case number CW 123098. This one was finalized in 2017, Your Honor. And
a child welfare case?
Yes, Judge. And I'm trying to see if there was an order regarding that. The other case that is linked to this case was a protective order, Your Honor, and that was a while back.
Okay, and that protective order, did it go through? Were you aware of that, Mr. Palacios?
Judge, we can't get that information on a non-secured site.
No,
Even on
but
our-
did your client tell you that there was a protective order?
No, Your Honor.
Okay, I understand you don't have access to it. But the thing is, so Ms. Garcia Cuellar, do you recall a protective order that you filed against Mr. Cuellar?
Yes, Your Honor, this is a case that dates back to 2011. It has been closed out. It was in a case regarding Mr. Cuellar, and that's when we separated, and it's been closed out.
Okay, I understand, but there's different closed outs. Okay, so is it that it was closed out because a protective order was issued, or was it because you dropped the case?
The case was closed out.
No, Miss, you have to understand, like, did you get a protective order? Was it a 2-year protective order, or did you cancel it, drop it, or anything like that?
It was after the year or 2 years. I'm not really sure. This was dating back about 8 years ago. The district attorney's office called me and said, do you want to continue to pursue? At that point, we were done because the proceedings had been filed, and he was then at that point taken from his visitations were taken. And so there was no need for that.
Okay, so then you never had a protective order issued against Mr. Cuellar?
That I recall, there was one administered, but it wasn't filed because his rights were termed at the same time.
His rights can't be terminated. So Ms. Rivera, go ahead. What were you gonna say?
Judge, I do see here, Judge, there was a final protective order that was signed on December the 7th of 2009.
Okay, so you did have a protective order against him back in 2009, but it expired in 2011. Okay, those are things you need to let your attorney know. Okay, so the other thing too is, all right, I'm gonna give your attorney an opportunity. You need to give him that OAG number because he needs to find out whether or not there is already you're saying that there's an order on file with respect to arrears. And so that means there's a financial activity report out there that your attorney needs to get his hands on so that there's a judgment if you're going to take that judgment. If not, you're going to end up having issues with the OAG's office. So I'll give you an opportunity to do that. So I think it's gonna take you a little bit longer than a week. So come back on March the 9th at 9:30 and make it, it has to be a quick announcement on that day because we do have a trial setting on that day.
I'll do, Judge, and if there is, I'll also file a motion to consolidate.
Okay, so make sure that you get Mr. Cuellar's, Mr. Cuellar, do you have an email address?
Yes, ma'am, I do.
Go ahead, what is it?
Ruben.cuellar96@yahoo.com.
All right, okay, so you'll receive the link at that email address for March 9th at 9:30, okay?
Yes.
And we'll send them a notice to Judge.
All right, thank you.
Thank you, Judge. I have nothing further to report. The Honorable Court might be excused.
Yes.
Thank you.
Thank you.
Thank you.
You're excused, Mr. Cuellar and Ms. Cuellar.
Thank
Okay,
you.
Mr. Cabrera?
Yes, Your Honor. Can you hear me?
Yes.
I'm number 20 on your docket. It's a Rule 106 service motion for substitute service.
Okay, and I'm sorry, what number did you say?
It should be number 20 on your docket, Your Honor.
Okay, I keep getting some feedback. Hold on. It's CL 21-3785-I Discover Bank versus Michelle Uribe.
Yes, Your Honor.
Okay, and the court will take judicial notice of all the documents in the court's file. And go ahead, you have, let me go ahead and.
We've made 5 attempts to serve the consumer, the defendant, and we have an affidavit from the process server describing each of those attempts in November, 3 in November, 2 in December. We also have attached to the packet the CAD, the CAD.
Hold on, Mr. Cabrera, I'm sorry, you have really bad feedback.
Sorry.
I'm not sure if it's your, what it is, but.
It's probably, yeah, it's on my end. I apologize for that.
Okay, hold on, the court's gonna take judicial notice of all the documents in the court's file, specifically the motion and the exhibits, therefore is granting your motion for substitution of service, and go ahead and get that order granting on file.
Thank you, Your Honor. That's all I have. May I be excused?
Yes.
Thank you, Your Honor.
Okay, Ms. Palacios Cruz?
Good morning, Judge. Number 2 on your docket.
Good morning. F 2089-19-9 in the matter of the marriage of Janet Ramirez and Jose Ramirez.
Yes, Your Honor. The parties have mediated this matter. I believe that we're ready to prove it up. There is still one outstanding issue. I was not able to contact my client this morning, but we should be able to resolve that.
Okay, and are you ready to prove it up now, or did you need another setting?
Your Honor, my client is not available for prove up. I'm not sure if Mr. Dennis Ramirez's client is available.
Your Honor, good morning. Dennis Ramirez on behalf of Janet Ramirez, the petitioner. I believe she's logged in, Your Honor.
Okay, Janet Ramirez, can you hear me? Okay, now, the
There she is,
issue.
Judge. She's
Okay,
in the red.
the issue that you have not been able to work out, did you need some time to work it out, or were you still gonna move forward with the prove up?
Your Honor, with the court's permission, I think we can prove it up. This is an MSA, and what I would suggest, and with the court's permission, perhaps set it up for a submission date here within the next 2 weeks if it hasn't been submitted. But I firmly believe in with counsel's word. She's never let me down. I have no reason to not move forward today. And I know counsel and I and the clients are very eager to get this divorce closed.
Okay, are there any minor children?
There are no minor children, Judge. The only issue was a community property house that was contested, but we did reach an agreement as to that issue.
Okay, Ms. Palacios Cruz, do you have any issue with moving forward with Ms. Ramirez's testimony?
We do not, Your Honor.
All right, then we'll just go ahead and move forward, and I'll let you all finish out the tying up the loose ends. So let me go ahead and have her unmute. Ms. Ramirez, can you please unmute?
Okay.
All right, raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may lower your hand. Go ahead, Mr. Ramirez.
Ms. Ramirez, can you please state your full name for the record?
Janet Aguirre Ramirez.
And you're the same Janet Aguirre Ramirez that has filed for divorce against your husband, Jose Ramirez?
Yes.
And you're asking the court to grant you a divorce today based on irreconcilable differences. There's no reasonable expectation of reconciliation, correct?
Correct.
And of this marriage, there were no minor children. They're all of age. Is that correct?
Yes.
No other children were adopted. None are expected at this time, correct?
Correct.
Prior to the filing of this petition for divorce back in 2019, you were a resident of the county and the state of Texas your entire life, correct?
Yes.
And I'm sorry, Hidalgo County, correct?
Yes.
And certainly 60 days have passed since the filing of this divorce, correct?
Yes, sir.
With respect to the community property that was acquired during marriage, we went to mediation on August 30th, 2021, and we were able to resolve all the issues at that time, correct?
Yes.
And with respect to the community property residential home located at 1807 Victoria Street in Edinburgh, Texas, Mr. Jose Ramirez was awarded that as part of this agreement. Is that correct?
Yes.
And in exchange for the award of that to him, he has agreed to pay you $30,000 for your share of the interest in that marital home, correct?
Yes.
And that'll be done with respect to a lump sum payment and monthly payments that we've agreed to that will be set forth in the final decree of divorce, correct?
Yes.
Now, as a result of this agreement, you've also agreed to waive any and all retroactive child support or medical support for the children that are now emancipated. Is that correct?
Yes.
We've also agreed to waive any other interest in any other personal accounts or retirement accounts or personal property. Basically, whatever is his and whatever is yours, correct?
Yes.
And just for the court's knowledge and information, you all have been separated for how many years now?
Since 2013. So
Okay.
about 8 years.
Okay. And also as a result of this agreement, Mr. Ramirez shall be keeping the 1985 Ford F-100 pickup truck.
Yes.
You'll be keeping the 2005 Hyundai.
Yes, but I have not gotten it.
Okay, and we'll include language in the decree that it shall be delivered to you upon filing and the court's signature of the agreed final decree. Are you comfortable with that, ma'am?
Yes.
Okay, Your Honor, no further questions at this time.
Okay, Ms. Palacios Cruz, do you have any questions of Ms. Ramirez?
Your Honor, I would just be asking if she would be requesting a name change.
Yes.
Okay, and what is that name change to be?
Janet Aguirre.
Okay. All right. Anything else, Ms. Palacios Cruz, of her?
No, Your Honor.
Okay, so the court is going to approve the agreement as testified to in the record and also to be set forth in further detail in a final decree of divorce to be submitted by, I'll give you all until March the 18th. That's about 3 weeks to iron out any details.
Thank you, Judge.
Okay? And
Yes.
therefore, I'm granting the divorce today.
Thank you, Your Honor. May we
thank
be
you.
excused, Judge? Nothing further before this honorable court.
Yes, you may. Ms. Palacios Cruz, do you have anything else?
Yes, Your Honor, I do have one more matter, number 6 on your docket.
F3397-21-9 in the matter of the marriage of Kimberly Escobedo and Cosme Escobedo.
Your Honor, we're set for final hearing this morning. I do not see opposing counsel on on the screen.
I haven't seen opposing counsel on this case at all. I don't know how your communication has been with him.
Judge, we're emailing a divorce decree back and forth as we speak, ironing out the details. There are children involved in this case, so I'm sure the court would like a prove up on this matter. So I'm not sure if the court wants to reset us when Attorney Jimenez can be available.
Well, I'm gonna follow your lead, Ms. Palacios Cruz. What I would probably think is that at least if they sign off on it, and at least if your client can prove it up, I'm fine with that.
Okay, Your Honor.
Because if not, I don't know when they'll get divorced. So do you want to do April 11th? That's the earliest I have.
Sure, Your Honor, that would work.
April 11th at 9:30.
And that concludes my business with the Honorable Court.
What is your name, ma'am?
Kimberly Escobedo.
Oh, yes.
Yes, ma'am. The case seems to be reset. I mean, can the lawyer be called and for him to, pop in?
Ma'am, Ms. Palacios Cruz has already notified Mr. Jimenez about these hearings. He knows he's supposed to be here. Unfortunately.
I saw him on the docket or, on the list of participants. I saw him earlier and then.
Well, he's not here now. So the fact that it's not moving, I can't tell you anything because the only one that keeps appearing is Ms. Palacios Cruz. So I would suggest you have a conversation with your attorney, and I don't know. If you want this done, then you need to have him communicate with Ms. Palacios Cruz, get that divorce decree done, and I'll be glad if it's signed off by all of you. I can see you earlier than April the 11th. But at this time, I'm gonna give her enough time to continue to communicate with him. So just, I don't know what to tell you.
Yes, because I went to their office yesterday to sign.
Okay, I don't know what to tell you, ma'am, because what they need to notify her if that's going to be the final draft. So she can only do what she has information with, and right now the best that I can do is set you for April the 11th at 9:30, and if it's signed off before then you can contact me. I mean, Ms. Palacios Cruz can contact us and we'll be glad to hear you sooner. But other than that, it'll be April the 11th at 9:30.
Okay, thank you, Judge.
All right, thank you.
Thank you,
Okay,
Judge.
thank you, ma'am. Have a good day. Yes, ma'am. All right, Ms. Cedillo?
Hi, Judge, good morning. I have number 18 on the court's docket.
F 2643-19-9 in the matter of the marriage of Julian Rodriguez and Abigail Rodriguez.
Yes, Your Honor, this is my motion for entry because we have not heard from counsel with regards to a decree. They've since provided that decree to me, Your Honor, but there is a few issues on it. One of the main issues that may cause a delay for a final is that they are, as part of the agreement, Judge, my client was going to allow access through a property that was landlocked, Judge, and we have no opposition to that. They were in agreement. The problem became they wanted an actual legal description to award that property to him so that there is no issues in the future, which I don't necessarily disagree with, Judge, but that surveying hasn't been done to get a legal description on that. And so I've indicated to Mr. Martinez that we're not opposed to that as long as it gets done immediately, Judge, so that we can put that legal description into the decree and finalize this case, Your Honor.
Okay. So how much time are you asking for?
Your Honor, just so that it remains on the docket, Judge, I would ask the court to give us at least 45 days for entry so that the surveying can be done, within the next week or so, and hopefully have some more information by then.
Okay, go ahead and file an order resetting on your entry for April the 13th at 9:30.
Yes, Your Honor. And just for the court's awareness, Judge, Mr. Martinez is from San Antonio and had another hearing, so I indicated I would make that announcement, Judge.
Okay.
And that was April the 13th, Judge?
At 9:30, yes.
Yes, Your Honor. Having no further business before this honorable court may be excused?
Sure, thank you. Okay, Ms. Matter?
Good morning, Your Honor. I am here on number 25 on your docket. I represent Progressive.
CL 21-467-I, Progressive County Mutual Insurance Company versus Eva Sanchez. Does Ms. Sanchez have representation? Do you know?
No, actually, Ms. Sanchez hasn't made a formal answer in this case. It just, according to my notes, she appeared at our, at the last hearing, which is why you reset it for a status hearing.
Okay,
So
Eva Sanchez. Eva Sanchez?
Your
Okay,
Honor,
yes, go ahead.
the email that she provided was, I sent her the link to the email that was provided the last time. It was returned, Judge. It is not a working email anymore.
So I did
Okay.
email her as well, but I didn't get any sort of response, but I emailed her on January 19th. So I think just a day or two after the hearing.
Okay, what email did you use?
Probably the same one. The email I use is evaromo1970@gmail.com, which is what I was given in the
Okay,
correspondence.
is that the same one that we use, Ms. Rivera?
Double check, Judge. No, Judge, I had Eva ROMEO 1970 @gmail. Not Eva RONO 1970 @gmail. So it was different.
Oh, that's strange. So the summary I have from the last hearing just had it spelled differently, but mine did go through.
Okay, well, what we'll do is I'm gonna have Ms. Rivera get with our court reporter, Ms. Flores, to see what's the email that was put on the record.
Okay.
And if it's the one that you did, then somehow we've got another one. We'll go ahead and set this for, let me go ahead and just have you come back for a quick reset on March the 9th at 9:30. And then we'll see if it goes through. And if it doesn't, then if you can, we'll see what happens. If it doesn't, then we'll have to mail her the notice.
Okay, and I can also have my office mail the notice as well.
Okay, and the notice, if for some reason she doesn't show up at that one, then of course you can file a motion for summary judgment or whatever it is that you want to do.
Okay, yeah, the original hearing was for a default judgment, and then she had appeared, which is why we were reset for the status hearing. So, okay, perfect. I will make sure that we also notify her via the email and the address we have, and I will be back here on March 9th.
Okay, thank you so much. I appreciate it.
Thank you, Your Honor. And that's all I have for the court this morning, if I may be excused.
You certainly may. Thank you.
Thank you. Take care.
Likewise. Mr. Contreras?
Yes, Your Honor, I'm here.
Okay, go ahead. What case? Ms. Williamson is, I think that's on your case. Is that correct?
Yes, it is, Your Honor.
Okay, F7172-15-9 in the interest of minor children. Go ahead, Ms. Williamson.
Your Honor, it's on his motion to modify. We both had motions to modify in this case. We are asking that the terms of the order remain the same at this point.
Okay, Mr. Contreras, so then you're still representing yourself?
Yes, ma'am.
Okay, so then we're not ready for a final hearing today then?
So you're saying I need an attorney?
No, I'm not saying that. I'm asking if we're ready for a final hearing.
Ma'am, I'm just asking for some time because y'all have been pushing this case for 2 years now.
Okay, not you all. Don't be trying to drag me into anything. And also, I do not know what's been going on with this from an attorney's perspective. So you can't say that Ms. Williamson has either been pushing it either. And then plus, it's also difficult to work with a pro se respondent. So Ms. Williamson, you were set originally for a final hearing, so it's not ready for a final hearing?
Your Honor, unless he wants to modify anything, this started after the child was not returned after a visit. There is a SAPSR order out of the Attorney General's office. So we had to do a motion for issuance of a writ of attachment, got the child back, and visitation. We had requested that all visitation be supervised at that time. Since then, visitation has not been supervised. We did enter into a temporary order, but we're ready for the terms of the temporary orders to continue. I don't know what he wants at this point.
Give me one moment.
Yes.
Your Honor, same to you.
Okay, what were you saying, Mr. Contreras?
Yes, ma'am. That thing that Ms. Williamson is talking about where I didn't drop off my child, that's falsified. Brianna lied. I was there. I made a report. I called her several times. She did not pick up. 3 hours passed. I made a report with the officer. I asked the officer if I could take my son home because I didn't have AC in my vehicle. I took him home. 3 hours passed. And then Brianna was at the police department with the sergeant claiming that I wasn't there. I told the sergeant, look up the report, and I was there. She lied.
Okay, hold on. I'm not, that's not what was my question right now, because that's getting into something. So you filed a motion to modify, they have a motion to modify. So today you are set for a final hearing. Are you telling me, all I need to know right now, Mr. Contreras, is if you're in agreement with the terms that have been proposed to you by Ms. Williamson?
I haven't been.
I'm sorry, you're cutting out. You're still cutting out, sir.
I'm not. So I do not know what you are talking about.
Okay, Mr. Contreras, I'm sorry, you have a really bad connection.
I have not been proposed anything.
Your Honor, if you would like to reset us, and I will send him the original order that they entered into many years ago that they were following. That's all that we're asking continue. This child support order has been going on since November of 2015.
Okay, and also Ms. Williamson, what you can do is if you want, you can do a, go ahead and do you can do an order setting final hearing. I'll set you for a contested hearing and I can hear it for
Yes,
final. So if you want to go ahead and do that, we'll go ahead and set you up for an order setting final hearing, and we'll give you a morning to do that. And then that way I can just hear it.
Yes, Your Honor, I will go ahead and do that.
I just want to know if I'm going to see my son again.
I'm sorry?
I just want to know if I'm going to see my son again.
Well, that's why we're going to do the order setting final hearing. I haven't heard anything from her that she's not going to want you to see the son. There may be certain conditions with it, but it's not to say that you're not going to see your child.
It's just been 2 years now. You all have taken a lot from me.
Okay, do not say you all, because I have nothing to do with this. So we're going to set you up for a final hearing on that day, sir. It will be finalized, okay?
Now, how long is that going to be, ma'am? What's the next date?
Well, we're probably, Ms. Williamson's going to get that filed, so it'll probably be within 45 to 60 days.
Of course.
Okay? Okay, he froze.
He froze. Yes, Your Honor.
Okay, that's fine.
I'll submit it today, Your Honor.
Okay, thank you.
Your Honor, I also do have the number 1 case. I know Mr. Sahadi was gonna make an announcement on it because we could not come to an agreement.
Okay, let me recall F1355-15-9. Mr. Sahadi?
Yes, good morning, Your Honor. James Sahadi on behalf of Armando Solis. Judge, no, I'm respectfully requesting a brief reset, Judge. The next setting would be perfectly fine. I anticipate that the children will need to testify in this matter. And I'd like a little bit of time in order to get that coordinated so I can go ahead and have them testify.
How old are the children?
There is a,
well, what's the issue? Is custody the issue?
Yes, actually, Your Honor, back custody, where the children have been living. The kids are 22, 20, 17, and 15.
Okay, so the issues with the 15 and the 17-year-old.
That's correct, Your Honor. And really just with the 15.
And let me ask you, are the proper pleadings on file saying that custody is at issue?
Yes, ma'am.
On both sides? I've only seen it on your side, I think. I'm not sure. Mr. Sahadi, were your pleadings at that time asking for custody?
I believe that pleading should be on file, Judge. I'll have to check. It's been a while since our last pleading.
Your Honor, and I understand, it probably benefit us all. I know that the sides are so opposed, and I mean, one of the sides is not being as accurate as the other. But Your Honor, this has been going on delayed since 2015. If we can just have a very brief reset, I think it's something that's can be resolved in an hour at the most, Your Honor.
Okay. No, okay. So do both of y'all think that you're gonna come up with an agreement?
Yes, Your Honor.
Wait, I'm sorry, what was that, Judge?
Now, do you think that you'll be able to come up with an agreement if you're given some time to talk?
Judge, I don't believe so. I think that the issues are.
So then this is what we'll do. Go ahead. What you'll do is you'll file a motion for me to confer with the children, and I'll confer with them first. And then we'll see what the next step is. When I confer with the children, I'm going to expect for the attorneys to also be there because I'll confer with you after conferring with the children. And after conferring with them, I'm pretty sure we'll all come to an agreement. Okay?
Yes, ma'am.
So,
yes, Your Honor.
All right, so go ahead and get that motion on file and I'll set it. And then we'll have them, they're both in school. I usually try to do when they're on a holiday, and if not,
well, spring break.
I know spring break's coming up, so.
Yes, but I won't be here. If not, I also do Saturdays.
Yes, Your Honor.
So,
Judge, I don't know if your spring break is going to overlap with their spring break. They may have different weeks. I don't know what week.
okay, so the week that does not work for me is the week of the 14th.
14th.
So if they have a different spring break other than that, let Ms. Rivera know.
The 14th, no, that's spring break, Your Honor.
Okay. And find out what time they get out of school.
Yes, Your Honor, and that's it. Really, it's only to the younger one. I don't know if they want both of them, but the younger one's the one that wants to talk and wants to testify.
I think the other minor has a lot to add as well, Judge.
Well, the thing is I talk to them first before I let them testify, because you do not want to. One, you don't want to make them feel like they're the ones with the power, because that's not the case. And two, you also don't want to make them feel like, they're going to hurt one parent or the other.
Yes,
so,
right.
So let's go ahead and do that. And then I'll work with their schedule. Okay.
Yes, Your Honor. And I'll submit it right now. Thank you.
All right. Perfect. We'll see y'all soon.
Thank you.
Okay. Kristen Gutierrez, Ms. Gutierrez.
Yes, good morning, Judge. I'm here on behalf of Greg Kurt. I think it's case number 13 on your docket.
Okay, so are you a new associate over at Jones Galligan?
Yes.
Well, welcome to Court 9, Ms. Gutierrez. Nice to meet
Thank
you.
you. Nice to meet you as well.
What law school?
St. Mary's.
Oh, fellow Rattler. I'm an
Yeah.
alum from there. All right. CL 196080-I Miguel Perez versus David Hovick et al.
Yes, Judge, we're here on a motion for disbursement of bond. We initially appeared in the JP court where an eviction was ordered against the defendants, I believe in November of 2019, at which time they filed an appeal and they posted a bond with the court. Defendants have not pursued the case up until this point. Notice of this hearing was sent to the defendants at their last known address with the court. And due to their failure to pursue, we're requesting that the case be dismissed and that the bond posted by the defendants in the amount of $500 be released to our law firm, counsel for Miguel Perez.
Okay. So is there anybody here? David Wayne Hovick, Fidel Solis III? David Wayne Hovick or Fidel Solis III? Okay, nobody appearing. I do see, I'll take judicial notice of the documents in the court's file, specifically that the order setting hearing for today was forwarded to the last known addresses of the defendants, and there being no response nor anyone appearing on their behalf. Then your motion is granted now.
Thank you, Judge. I believe Mr. Kerr filed a proposed order, so it should be there.
Yes, the order was filed on January the 11th, and I'll ask for that to be forwarded to my queue so I can sign off on it. Well, that was a good win for you.
Thank you, Judge.
Okay, come by our office and say hi.
I will. Thank you. May I be
All right.
excused?
You certainly may. Thank you. Okay, Mr. Pennebaker.
Good morning, Your Honor.
Good morning, sir.
This is our motion on behalf of the homeowner for clarification of your appointment of an umpire, and also a motion to compel appraisal with the umpire that you appointed. Mr. Michael De Leon and I are here and ready and represent the homeowner, Ms. Blanca Lopez.
Okay.
Morning, Judge.
Good morning, sir. Hold on.
Number 16 on your docket, I failed to advise the court. Sorry, Your Honor.
Yes, I have it. Okay, go ahead. What is the clarification?
Yes, Your Honor. So the issues surrounding this are out of an appraisal. This was a Hurricane Hannah claim on Ms. Lopez's home. On November the 13th of 2020, UPC demanded appraisal and named their appraiser, Tom Kowalewski. On June the 13th of 2021, Ms. Blanca Lopez named her appraiser, Jordan Quiroz. Initially, her appraiser, Mr. Quiroz, agreed to Randy LeBlanc to serve as the umpire. However, prior to this court appointing Mr. Rigney as the umpire, Mr. Quiroz withdrew his consent to Mr. LeBlanc serving as the umpire. And as a result of Mr. Quiroz withdrawing his consent to Mr. LeBlanc as an umpire, there was no longer an agreement on who would serve as the umpire. And so on behalf of the homeowner, we filed on April the 28th, our motion or application to the court for the appointment of an umpire. And in that motion, we've proposed 2 umpires. The court, however, issued its order on May the 4th, 2021, selecting John Rigney to serve as the umpire. And on that same date, May the 4th of 2021, the court sent a copy of that order to all counsel of record, including Mr. Ronald Hornbach, that represents UPC Insurance Company in this appraisal. So UPC Insurance Company is the insurance company that insured the home. This is really important, Your Honor, because Mr. Hornbach had received a copy of the court's order designating Mr. John Rigney as the court's appointed umpire, which the court was fully within its authority to do. And even though Mr. Hornbach knew of our application to the court and the court's appointment of Mr. Rigney, he took some rather shocking or alarming steps on behalf of UPC against the interest of their own insured, Ms. Lopez. Especially if you consider, and I know the court knows that you know, insurance companies still owe a duty of good faith and fair dealing to deal fairly with their homeowners, whether it's an appraisal or the claim or what have you. And so rather alarmingly, Mr. Hornbach, on behalf of UPC, totally ignored the court's order and more or less conspired with their appraiser to secure an appraisal award that was signed by Mr. Randy LeBlanc without the participation of the policyholder's appraiser, Mr. Quiroz. And Mr. Quiroz had already withdrawn his consent to Mr. LeBlanc. It gets really worse than that. We found out that Mr. Hornbach, on behalf of UPC, to get this umpire to go forward at the exclusion of the homeowner's appraiser, you know, Mr. LeBlanc had sent a bill to each side, $1,250 per side to do this appraisal. And of course, the homeowner didn't pay because they had already withdrawn their consent to Mr. LeBlanc. Well, Mr. Hornbach paid both sides. And the appraiser knew that. He paid Mr. LeBlanc $2,500 to go forward with this appraisal, even though Mr. Quiroz was no longer participating, and recognizing that the court had appointed Mr. Rigney as the umpire. And it's also our understanding that neither Mr. Quiroz or the homeowner ever allowed or coordinated an inspection by Mr. LeBlanc of the home before he issued this award. He issued this award on July the 30th, 2021, 87 days after the court appointed Mr. Rigney. Never at any point did UPC or Mr. Hornbach ask for clarification, as we have done, as to who should be serving as the umpire. They never filed a motion with the court. It was not until we filed our motion for clarification and to compel the appraisal with the court-appointed umpire that Mr. Hornbach ever filed anything with the court in response. So he's just simply filed a response to our motion. So what we seem to have here is a situation where UPC and their counsel knew that Mr. Quiroz, our appraiser, the homeowner's appraiser, had withdrawn consent to Mr. LeBlanc as the umpire. They knew that the court had appointed Mr. Rigney within the court's authority to serve as the umpire. They never contacted the court or applied to the court for any sort of clarification or to ask the court to overturn its own order or anything of that nature. Rather, they appear to have just gone forward, sort of conspiring with their appraiser and Mr. LeBlanc as the umpire to render an award that was, of course, as it turns out, I don't believe we actually received the award until they filed a response to our motion. But as it turns out, not surprisingly, the award was not favorable to the homeowner. Mr. LeBlanc, knowing that the homeowner contributed nothing or didn't pay the invoice. It just seems very out of the ordinary, very unusual a step on behalf of an insurance company to take to go ahead with an appraisal like that, knowing that there's a court-appointed umpire. And so what we're asking the court today is to simply, we've submitted an order to the honorable court to clarify that Mr. Rigney was the umpire authority based on the court's own order, and that he was the only one that had authority to render this appraisal award, not Mr. LeBlanc. And that really is the extent of our position, Your Honor.
Okay, and is anyone here for a response on behalf of United Property and Casualty Insurance?
Yes, Your Honor, I apologize. I did not get an opportunity to make an appearance earlier. I'm Caroline Horstman. I work closely with Mr. Hornback and I represent United Property Casualty Insurance Company. For several reasons, we disagree with the timeline that was offered by Mr. Pennebaker here. And as noted in our response, the timing on this matter is such that there was no notification of the supposed withdrawal of Mr. Carroz's consent to the use of Mr. LeBlanc as umpire. In fact, we have nothing to show that Mr. Carroz did not withdraw his consent until July 26th of 2021, which came after this court's appointment of an umpire dated, I believe, back on May the 4th of 2021. Mr. Carroz was copied on all communications in the appraisal process. Nothing was heard from him except his initial agreement on January the 26th of 2021 to the use of Mr. LeBlanc as umpire. There was no notice and opportunity to be heard given until our firm subsequently received this notification of an umpire appointment on or about that date in early May of 2021. So there's no power because we have nothing of this court to rule on this motion here because first of all, the agreement was in place, it was valid, there was nothing on our end from Mr. Carroz, and then further, Judge, the issue here is that Mr. Carroz wrote back on this July date, supposedly after the fact of this court appointment, said, well, he didn't check with the insured on the consent to the use of the umpire. That's not the policy. You don't have to go run in to check with your insured or check with your counsel. They agreed to an umpire, and that was the agreement. So this court then had no power to make an umpire appointment because there was that agreement in place. And further, Judge, this matter is actually not in suit. So the court's power is only to rule on the language of the policy, which only grants the power of a court, any judge within the state, to grant an umpire. But being that there was that prior agreement in place, then there was nothing further to be done. Mr. Carroz was copied on all communications during the appraisal process, and he was not responsive. He was not communicating back to any emails. He was notified that an inspection was to be conducted, but I think the issue really is that the court has no authority to rule on this motion that's here before the court.
Anything else?
Just a brief response, Your Honor. I disagree completely with opposing counsel's position. The reason that we filed an application to request the court to appoint an umpire on April the 28th of 2021 is because we received word from Mr. Carroz that he had withdrawn his consent. Otherwise, we wouldn't have filed the motion with the court because there would have been an agreement in place. And I'd never heard a response and never heard anything rebutting the information that we included in our recent motion that Mr. LeBlanc actually inspected this property, which is another huge concern. I can't, and especially after his entire invoice was paid by UPC. And so it just seems, and if you look at page 3 of opposing counsel's response, they admit, at least, I mean, they're not going to come right out and admit probably much, but they admit that prior to the appraisal award being rendered, they did receive word from Mr. Carroz that he no longer consented to Mr. LeBlanc. So prior to the appraisal award being signed by their appraiser and the umpire, Mr. LeBlanc, they knew that Mr. Carroz had withdrawn his consent, and that alone should be sufficient and would enable this court to appoint an umpire, which it did. And that's all I have, Your Honor.
Okay.
May I respond, Your Honor, just briefly?
Yes.
To rebut that. So we have documentations, we have emails from appraisers where Mr. Carroz was copied and an inspection was scheduled for July the 12th of 2021, and Mr. Carroz did not respond to that. That was the inspection that was scheduled between our appraiser and Mr. LeBlanc, the umpire. And then, I mean, we have documentation
We have we have information from our client and no information from Mr. Quiroz that anyone ever coordinated with them and actually did an inspection with the umpire. If Mr. LeBlanc did an inspection of this property, it was out without our client's knowledge and consent.
Okay, anything else?
Yeah, yes, Judge, very briefly, again, just there's no authority of this court to rule on this motion. So I mean, it stops with there. It stops with the language of the policy and the prior agreement of the appraisers. And we have nothing to show for it. I mean, he can say Mr. Quiroz withdrew all his consent all he wants, but we have no documentation of that fact, Your Honor.
Okay. Well, I disagree. I'm granting the order clarifying the umpire appointment. Only Mr. John Rigney is the one that has the authority. So I'm signing that order. And I'll have that forwarded to my queue and I'll have that sent out to all of you. All right, if nothing further, you're excused.
Thank you, Judge.
Okay, Mr. Morales?
Yes, Judge, we're here.
Okay, go ahead.
Judge, we are ready to proceed, Judge. We're going to need a short hearing, Judge. We're here.
Okay, so this one is on which one?
On number
4?
Yeah, number 4, Judge.
Okay, so Mr. Ochoa and Ms. Zamora on that one?
Yeah,
that's correct, Judge. Pepe Guerrero here for Ms. Zamora. It's one of the cases I had this morning. We had settled this case and pursuant to the settlement agreement, we're just waiting for some temporary orders from Mr. Morales' office, so we can at least get that done.
Okay, hold on. Let me look this up real quick.
Your Honor, and if I may, for the record, Cynthia Cantu del Bosque, guardian ad litem for the children.
And Polo Gutierrez for the Office of the Attorney General.
Okay, so we're still dealing with the issues. Because I remember this case. So an intervention was filed by the AG's office. So what are the outstanding issues?
Well, I mean,
are y'all still arguing over custody?
Yes, Judge.
Okay.
Yeah, unfortunately.
Okay, so you have a mediated settlement agreement on file from back in September on temporary orders. So first, the temporary orders, who was to draft them and get them sent over?
We were waiting for Mr. Osvaldo Morales' office to send us the proposed temporary orders. He was the petitioner in the case. So.
Okay, so first, I need those temporary orders on file.
Right.
And signed off by all parties. And then you're saying that you need the custody issue. Now, do you all have everything that you need from each other as far as discovery is concerned so that we can set this for a final hearing? Are you going to do a bench trial or are you doing a jury trial?
Oh,
I'm okay with the bench trial, Judge. It's up to Mr. Guerrero.
Okay, Mr. Guerrero?
Yeah, I don't have any problems with a bench trial on this one, Judge.
All right. So let's get the temporary orders on file since you do have a mediated settlement agreement on that and you can follow those temp orders and file an order for DCC. And then I'll get you set up for a bench trial. Do you all have all the discovery you need or did you still need more discovery to move forward on a bench trial?
I don't need anything further, Judge, but.
Okay, so that way my court coordinator knows that if you have everything, we can go ahead and set you up sooner than later. Okay? So we'll go ahead and do that. And don't forget to include Ms. Del Bosque and also Mr. Gutierrez on that DCC so that we can get their schedules if they're going to be also involved.
Okay.
Well, Ms. Del Bosque has to. I don't know if Mr. Gutierrez.
We'll do that, Judge.
Okay, and I'm going to tell you more or less. Hold on. We are probably going to be looking at like April the 20th, April the 27th, maybe somewhere around there.
That'll be,
That way you know, but get those temp orders in so I can sign off on them in case anything happens. If you're
okay,
gonna need for me to confer with the children again, let me know so that we can get that set up. And that's gonna be in person this time.
we'll do, Judge.
Okay, anything else?
I have a couple of other cases, so I won't excuse myself, but on this one, can my client be excused? Judge?
If nothing further on this, Ms. Zamora and Mr. Ochoa are excused.
Your Honor, I have nothing further before this honorable court. May I be excused?
You certainly may.
Thank you, Your Honor.
Me
Mr.
too,
Morales, you
May I
still
be
have
excused?
Hector Garcia and Cassandra Garcia?
Yeah, I believe we did, we're gonna do a Rule 11 agreement to pass this case. This is Mr. Salinas, Judge, I believe.
Okay, and how much time do you need on that?
1 week, Judge. We're gonna try to settle it tomorrow. We're gonna do an informal mediation tomorrow.
Okay, March 9th at 9:30?
March, Judge, I'll be back on the 10th, Judge. I'm gonna be out of town on that day.
Okay, the 23rd.
Okay. Thank you, Judge. May I be excused?
Yes, thank you.
Thank you.
Okay, Mr. Guerrero, what else do you have?
I have Mr. Victor Jaramillo, Judge. That's he's for the 9 o'clock docket, 9:30 docket. I believe it's F 3243-11-9. It's it was a case that was transferred to this honorable court. We filed a motion to modify the orders of custody and support. The subject child is a 14-year-old child, and we served the respondent parent, the then custodial parent, Mayela Corruya Sosa. She was served, Your Honor. She did file an answer. In her answer, she did not provide an address, but we, in giving her notice of this particular hearing, we had the order sent to the address that we originally served her at. And my client seeking primary custody of his daughter. His daughter has expressed a desire to live with him. And we're asking this court if the court feels it's necessary to interview the daughter to confirm that she does want to live with her dad. So that's what we're seeking to do in this case, Your Honor.
Okay, you're representing Ms. Sosa, correct?
No, I'm representing Mr. Victor Jaramillo.
Okay, and who's representing Ms. Sosa?
Ms. Sosa at this point is pro se. If the court takes a look at her answer, she states in her answer that in paragraph 3, I cannot afford a lawyer. I cannot afford to pay for the other party's lawyers his fees. I am asking this court not to force me to pay the other party's legal expenses. I mean, I take that to be that she's going to proceed pro se from that statement. In the case of Mr. Jaramillo, he's a responsible parent. They had informally practiced 50-50 split custody, where the child was living at 1 week with him, 1 week with her mom, mostly with him. But we want to change formally the designation and have Mr. Jaramillo be primary, and also obviously have him not have to pay any more child support, because that wouldn't be right.
Okay, and is Mayela Sosa present?
Mayela Sosa? I don't know, Judge. I don't.
If I may,
Go ahead.
Your Honor, Ms. Mayela Sosa did call into our office a few times this morning. We did send her the link to the correct email because the email was not returned to us. She kept stating that she never received it. Our office did as well provide the call-in number. After we did provide that number to her, she kept calling our office, but we were unable to answer due to being on Zoom already.
Okay. So Mr. Guerrero, is your client available?
He's right there. He's on the camera, Judge. He speaks primarily Spanish dominant, so
Okay.
he would need an interpreter.
All right, Ms. Castañeda, please ask Mr. Jaramillo to raise his right hand.
Señor Jaramillo, por favor, levanta su mano derecha.
Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Jura que el testimonio que está a punto de dar es la verdad, y toda la verdad y nada más que la verdad.
Lo juro.
I swear.
Okay, Mr. Guerrero, how old are the children involved in this?
There's only one remaining minor child in this, out of this relationship. The other two have already, the adults and are not subject to the court's jurisdiction in that capacity. The child is KAJ. That's the youngest of the three children. And Mr. Jaramillo is seeking to modify custody.
What's the age? What's the age?
Age 14, Your Honor. She's 14 years old. 14
Okay.
years old. She was born in 2008.
Ms. Castañeda, please ask Mr. Jaramillo what grade his daughter is in.
Señor Jaramillo, ¿en qué grado de la escuela está su hija?
En grado 8.
En 8th grade.
What school?
¿Qué escuela?
Fasum.
Dispense?
En Fasum.
Fossil, is it elementary or middle school?
Elementary.
Fossil
Perdón.
elementary.
Perdón, es middle school.
Fossil middle school.
Fossum, F-O-S-S-U-M, Fossum Middle School. In McAllen?
In McAllen?
Sí.
Yes.
Okay. Go ahead, Mr. Guerrero, question your client.
Thank you, Judge.
And make sure you go slow, please, so that they can interpret.
Certainly, Your Honor. Mr. Jaramillo, are you the father of your daughter? And I'm going to give you the initials KAJ.
Señor Jaramillo, ¿es usted el papá de K-A-J?
Sí, de Catherine Jaramillo.
Yes, of Catherine Jaramillo.
Sir, and presently, your daughter, is she living with you, Mr. Jaramillo?
Al presente, señor Jaramillo, ¿su hija está viviendo con usted?
No, está en la casa con su mamá.
No, she's with her mom.
Can you describe for the court how you share custody with your daughter presently?
¿Puede describir a la corte cómo es que ustedes tienen la custodia al presente?
Sí, la niña me está pidiendo desde ya varios años que pida su custodia porque su mamá es difícil y no la trata bien.
The child has been asking me for a while to change about the custody because her mother is difficult.
But presently, do you share custody with the mother of your daughter?
Pero al presente, ¿usted tiene la custodia compartida?
Sí, tengo la custodia compartida.
Yes, we share custody.
So just so the judge will be aware, how is it that you share the custody? Okay, describe it for her.
Para que la jueza entienda, por favor, describa la custodia.
La custodia es ahorita la niña como está pasando por problemas con su mamá, me pidió que esté una semana conmigo y otra semana con su mamá. De hecho, a la mamá fue la que le exigió que así fuera y actualmente está quedándose una semana conmigo y otra con su mamá.
Okay, since the child is going with problems with her mom, we do 1 week on, 1 week off, and the mother is the one that asked for this 1 week on, 1 week off.
Okay. Mr. Jaramillo, are you asking to be the primary custodian of your daughter?
Señor Jaramillo, ¿usted está pidiéndole a la corte la custodia primaria?
Sí.
Yes.
And has your daughter expressed that she wants to live with you, Mr. Jaramillo?
¿Y su hija se ha expresado que ella quiere vivir con usted?
Muchas veces, ya tiene mucho tiempo.
A lot of times, it's been going on for a while.
And do you believe this is in your daughter's best interest that she reside with you, Mr. Jaramillo?
¿Y usted cree que esto es en el mejor interés para ella que ella viva con usted?
Así es.
Yes.
Ya que sus hermanos también los pedí y gracias a Dios ya logré que ellos tengan una carrera, sus hermanos, en custodia mía.
Her brothers, I had the custody too, and they've already had their careers.
Matter of fact, you informed me today that Daisy Jaramillo, your already, adult daughter has her own business as a loan advisor. Is that correct, sir?
Y hoy me advirtió que su hija Daisy Jaramillo ya tiene su propia carrera como una advisora de préstamos, asesoría de préstamos.
¿Es correcto?
That's correct.
And you also helped Victor Jaramillo Sosa, which is your son. Actually, you raised them and he now is an attorney. Is that correct, Mr. Jaramillo?
Y también a su hijo Victor Jaramillo, usted lo crió y ahora es un abogado, ¿correcto, señor Jaramillo?
Es correcto también.
That's correct too.
And you're confident that you will be able to do the same thing for your youngest. Is that correct, Mr. Jaramillo?
Y usted está confidente que va a hacer lo mismo con su hija, la menor, ¿correcto?
Sí, es el beneficio de ellos. Quiero asegurarme que estén bien.
Yes.
Now, Mr. Jaramillo, you also are asking that the court order that you pay no more child support for the upkeep of your daughter since she's going to live with you.
Y también está pidiendo a la corte que usted ya no pague el soporte financiero para la niña porque va a estar la manutención infantil porque va a estar viviendo con usted, ¿correcto?
Así es, yo me voy a hacer cargo de sus gastos.
That's right. I'm going to be responsible for her expenses.
And you're also asking the court to award Mayela Sosa, the mother, extended standard visitation.
Y también usted le está pidiendo a la corte que le otorguen a la señora Mayela, otorguen la extendida custodia, ¿correcto?
Correcto.
That is to say, Mr. Jaramillo, you don't have any problems with Mayela visiting her daughter, do you, Mr. Jaramillo?
Eso quiere decir que usted no tiene ningún problema con que la señora Mayela visite con su hija, ¿correcto?
No, ningún problema.
Not a single problem.
You're also asking, based on your knowledge, that Miss Mayela Sosa pay you child support since you're going to be taking care of Catherine. Is that correct?
Y usted también, basado en su conocimiento, que usted va a pedir que la señora Mayela le pague usted la manutención de la niña.
Sí, sí, lo estoy pidiendo también.
Yes, I'm asking for that too.
How much do you believe would be an appropriate amount of child support based on what you know?
¿Cuánto cree usted que debe ser la manutención?
Creo que ella me debe de dar para la niña $1,000 mensuales.
I think she should give me for my daughter $1,000 a month.
And you believe this amount of child support is in your daughter's best interest?
¿Y usted cree que esta cantidad de manutención es apropiada para su hija?
Creo que es poco, pero con esa ayuda, porque quiero hacerla una profesionista.
I think it's
soportar los gastos.
low, but I want to make her a professional.
Now, you're also asking that the court also order her to be responsible for the medical support, that is to say, medical insurance and dental insurance for your daughter. Is that correct?
Y también usted está pidiendo que, pidiéndole que hagan una orden de médica y dental, ¿correcto?
Sí.
Yes.
Correcto.
Correct.
And and you're all obviously, do you have anything else you want to add, Mr. Jaramillo?
¿Algo más que quiere usted agregar, señor Jaramillo?
No, pues solo quisiera que investigaran los ingresos de mi ex esposa para que vean que estoy correcto con lo que estoy
I want
pidiendo.
them to investigate her earnings so they can see that I'm correct.
Well, just for clarification, Mr. Jaramillo, to your knowledge, what does your ex-wife do for a living?
Nada más por clarificación, señor Jaramillo, ¿qué hace su esposa para vivir?
Es gerente en una compañía de produce en la central de abastos de McAllen
She's a manager in a produce company in McAllen.
y tiene una propiedad que está rentando departamentos,
And she has
pequeños
a family that she's
departamentos,
renting apartments.
y tiene un salón de fiestas ahí mismo.
And she has a party rental place.
So she's an accomplished businesswoman. Is that correct, Mr. Jaramillo?
So es una mujer acomplizada con con sus negocios, ¿correcto?
Sí, correcto.
Yes, correct.
Judge, I'm concluding my questioning.
How much did Mr. Jaramillo pay in child support?
Excuse me, Judge?
How much did Mr. Jaramillo pay in child support?
Under the order, Judge, Mr. Jaramillo was paying $360 a month of child support.
Okay, and have y'all seen any financials to support child support in the amount of $1,000?
No, we haven't, Judge. We really haven't.
Okay. What I'm gonna do, are you going to look at that further or what?
I mean, if the court, if and I know the child support is rather nebulous, right, Judge? But if the court wants us to investigate, then we would ask, in lieu of a final order, temporary orders establishing this as the existing order from the court. That way it'll stop child support, and I can send Mrs. Sosa some discovery regarding her child support, her income, and then come back to the court. And maybe by that time, Ms. Sosa might decide to hire someone to help her with it, with this case, or she may reach out to me and try to negotiate, more terms, as it were. That would be my suggestion to the court. And we did make a request for temporary orders when we filed the modification, just in case this case would have dragged on or would need to go further.
So my concern is just that, is that if he wants to accept anything higher than the amount that he was paying, then I would suggest that you all do exactly what you just said. If he's okay with accepting $360 a month, I can go ahead and finalize it today.
Can I ask him that? Mr. Jaramillo, well, I would need the translator, or can I read it briefly, Judge?
Well, he's in your office, so.
Okay.
So go ahead and go ask him. We'll take a brief recess.
Okay, thank you, Judge.
We'll give you a 5-minute break.
Thank you, Judge.
Mr. Salinas and Mr. Munoz, I'm going to need you all to report back at 1:30. My office will send you a link. Okay? Thank you. You're excused until 1:30.
Your Honor, this is Steve Efthimi. Can I say something?
Yes, I know you're on with Fabian's case, so I'm going to just conclude with the cases that you all have left.
I believe we have an agreement, so it should be quick.
Okay, great.
We're ready, Judge.
Okay, we are back on the record on F3243-11-9. Go ahead.
Judge, you'll accept the $360, which is the same amount of child support that she would pay him when she was primary.
All right. Then, given, the court is taking judicial notice of all the documents in the court's file, specifically that she did file an answer. She was given proper notice of today's hearing. And she was also sent the link for today and made contact with our office and yet still did not show up. The court is granting the relief as requested and testified to on the record. Child support will be set in the amount of $360 per month to begin on March 1st, 2022. And medical support is also to begin on March 1st, 2022. Medical support, is she already covered under her insurance, or what insurance does the child have?
I think the child goes through, that's a good question, Judge.
Ms. Castañeda, please ask Mr. Jaramillo what type of insurance his daughter has.
Señor Jaramillo, ¿qué clase de aseguro médico tiene su hija?
He's on mute. Tell him to take it off.
Por favor, prenda su bocina, señor Jaramillo.
Okay.
Okay, ask him.
¿Qué clase de aseguro médico tiene su hija?
El Amber,
They're on Ambetter.
Okay, who's been paying for it?
¿Quién lo está pagando?
ahorita mi ex,
Right now, my ex.
Okay, so then it's ordered that the health insurance that is in place is to continue, and Ms. Sosa is to continue paying the premium.
Okay.
Okay, get that order on file as soon as possible. Please, I'm going to give you until March 18th to submit it.
Thank you, Judge. May Mr. Jaramillo be excused, Your Honor? I still have one more case.
Yes, he may be excused. Ms. Castañeda, please let Mr. Jaramillo know that he is excused.
Señor Jaramillo, ya se puede retirar.
gracias.
Thank you.
Okay, your next case.
My next case, Judge, is Mr. Jose Andrade. He's present in my office. Steve, if you knew it was, and I have went to mediation. We were successful, Judge. We got this case mediated and settled.
Okay, that's F 3266-21-9 in the matter of the marriage of Jose Andrade and Jerry Andrade. I do see both parties present. And are we going to prove that up with your client, Mr. Guerrero?
Yes, Your Honor, we will.
Okay, let me have both parties raise their right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth? So help you God. Please unmute and answer.
Yes.
Yes, I do.
Okay, go ahead, Mr. Guerrero.
I apologize, Judge. I thought I had the agreement in my handy, but I guess I don't.
Well, basically, the agreement is from the temporary is that nobody established the primary residence. The parents have 1 week on, 1 week off. Neither party pays child support, and I'm not sure who has health insurance.
Okay, I thank you very much, Steve. I appreciate it. Yeah, yes, Judge. Now, it says as he stated, but there will be a geographic restriction, right, Steve?
Yes.
That's fine.
In Hidalgo County.
Well, actually, I want to see like here in the valley. So in case she wants to take her to the beach or to the zoo.
The geographical restriction is just to living, like where you all can both travel with the child wherever you want when it's your time.
All right.
Yeah, geographical restriction is just that the child's primary residence with mom is not going to be, she's not, did you all do Hidalgo County or what geographical restriction did you do?
Hidalgo County, Judge.
Okay, in other words, mom's not going to move from Hidalgo County and dad's not going to move from Hidalgo County. That's what it means. You can vacation wherever you want, whenever you have your child. Okay, but since this is a divorce, I do need for you to prove up the elements with Mr. Andrade, please.
Yes, Mr. Andrade, can you state your full name for the record, please?
Jose Heriberto Andrade.
You're currently married to Jerry Ann Andrade, sir?
Yes, sir.
And before we filed this petition for divorce, did you live in this county and in this state the preceding 6 months prior?
Yes.
Okay. And you're asking for divorce based on you and Mrs. Andrade not being able to have because of the discord of conflict and personalities between you and her that have destroyed the legitimate ends of a marriage relationship, and there's no reasonable expectation of reconciliation. Is that correct?
Correct.
I'm going to tell you by initials, you have one child, it's a minor in this out of this marriage, and her initials are PSA. Is that correct?
That is correct.
Okay. Now you and Ms. Andrade have not accumulated any significant community property other than what you have in your possession and what she has in her possession. Is that correct, Mr. Andrade?
That is correct.
And as far as you know, you don't have any separate property, and neither does she. Is that correct, Mr. Andrade?
That's correct.
And you heard the agreement regarding custody and support of your daughter. Do you believe that to be in the best interest of your daughter? Is that correct? I mean,
yes, I'm satisfied.
And are you asking this court to grant you a divorce?
Yeah, I mean, I wouldn't want that, but if that's the case, there's no reconciliation. Yes, go ahead and grant it.
Okay. And I'll pass the witness at this time.
No question from this witness. I have a couple from my client.
Go ahead, Mr. Euthymio.
Ms. Andrade, can you hear me?
Yes, I can hear you.
Did you hear everything that was put on the record so far?
Yes.
And you're in agreement with that?
Yes.
And you're asking for a name change to Jerry Ann Williams, is that correct?
Correct.
And your middle name is Ann, A-N-N?
Yes.
All right, and you're asking for divorce as well?
Yes.
That's all you're.
Miss Andrade, are you expecting any child at this point?
No.
That's the witness.
No further questions.
Does she want a name change?
Yes, she wants a name change to Jerry Ann Williams.
William, okay.
Okay, and also, what about medical support? Who is covering the child with insurance right now?
Right now, she has Medicaid.
Okay, so who's the one that applied for the Medicaid?
I did. Yeah, she's had it for a while already.
I have her on my insurance as well from work, and she has a card. I gave Jerry a card of the insurance.
Okay, are you paying for your daughter, or is she on a family plan that is included with your employment?
I pay for my insurance and the employment.
Okay, but I'm saying, like, do they charge you for your daughter?
Oh, no.
Okay, so then right now you're not paying insurance for your daughter. It's not costing you out of pocket, and Miss Williams is paying insurance out of her pocket. I mean, has insurance, but is not paying out of pocket, correct?
Correct.
Okay. So then what they would have you do, the OAG's office, if they were involved, is they're going to say for Mr. Andrade to continue the medical coverage on the child, and that he would be responsible for the coverage because he's the one that can cover her through work. If at any time, Mr. Andrade, your work starts charging you for covering your daughter, it is up to you if you want a reimbursement from Ms. Williams. And if you do, then you need to contact the Office of the Attorney General at that time.
Okay.
And it would be half and half.
Okay.
Okay. So co-pays, since when you have Medicaid and the child has private insurance, they're going to take the private insurance first. And so if at any time there's a copay, the law says that each of you will pay 50-50. Okay. But you do have to notify each other because last time I checked, nobody was a mind reader. Okay. All right. Well, I know that this case started off rocky, and I commend you all for coming up with an agreement that has your child's best interest in mind. Remember that co-parenting, I know it's hard, but it's necessary to do it together, and you all have already taken the first steps at being good co-parents, okay? And just so I think you guys have both gotten to know how I am in this court, your case will always be in this court unless later on it gets transferred because we get new courts. But, you know, try to work it out before you put it in my hands. Because like you both know, I did this for 20 years and I'm always going to put your child first. So your attorneys can both tell you how I think. And so, but you guys did a great job. So I commend both of y'all, okay?
Thank you.
All right. Best of luck to you. This divorce is granted. Name change is granted. The relief requested is granted as testified to in the record and will be set forth in further detail in a divorce decree to be submitted and signed off by all parties by March 18th.
Thank you.
Thank you.
Okay.
Thank you.
Best of luck.
Good.
Thank you.
Okay. All right. I have Manuel Lopez. Mr. Lopez,
Yes,
you are
yes, sir.
filing a divorce against Laura Monica Lopez?
Yes, Your Honor.
Okay, and that's F 451309-9. Let me look that up very quickly. Okay, so the last time that y'all were here, we discovered that there was actually another case that had been filed. You filed an order on your motion to consolidate and I granted that. So
Yes,
now
ma'am.
both cases are, and we can move forward on your divorce. So go ahead and let me have both of you raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
You're on mute, Ms. Lopez.
Oh, yes, Your Honor.
Okay, you may lower your hands. Give me one moment. So we do have one minor child.
Yes,
And how old is she right now?
15.
Okay. And you have reached an agreement as to possession, access, visitation,
Yes,
and as to child support and medical support?
yes.
Okay, then we can move forward. All right, please state your full name for the record, Mr. Lopez.
Manuel Lopez.
And you are currently married to Miss Laura Lopez?
That is correct.
And what date did you get married?
Oh, do not remember. That was, I think
Okay.
17, 18 years ago.
Miss Lopez, do you recall your date of marriage?
I think it was March 15th. I think.
2005?
Yes, 2005.
Okay. And you all ceased to live together as husband and wife on what date? Mr. Lopez?
On or about May of 2009.
Okay. And you're asking for a divorce today because your marriage has become insupportable because of discord or conflict of personalities between yourself and Miss Lopez?
Yes, that is correct.
And this destroys the legitimate ends of the marriage. Is that correct?
Correct.
Is there any chance for reconciliation?
No.
Okay. And Stephanie Lopez has already emancipated?
Yes.
Okay. So she already graduated from high school?
Yes.
All right. So that leaves Isabel Lopez, a female born on July 21st, 2006. Is that correct?
That is correct.
Okay. And did you accumulate any community property during the marriage?
No.
And are you asking that all the debts that you've accumulated under your name and solely incurred by you that you pay, and any debts that Ms. Lopez incurred under her name and that she solely pay?
Yes, that is correct.
Okay. And what is the visitation schedule that you and Ms. Lopez have agreed to as to your minor daughter?
It's kind of hard. There's no set day. It could happen any day. The thing is that our daughter is in a band and she's pretty busy with that. So it's whenever it's possible.
Okay, so then it's as per agreement of the parties?
Yes.
Okay,
Yes.
Ms. Lopez, is that your understanding as well?
Yes.
And how is your daughter covered for insurance?
She has Medicaid.
Okay. Mr. Lopez, is insurance available to you through your employment?
Yes, ma'am.
Okay. Have you tried to have her covered?
No, I haven't.
Okay. The thing is that the Office of the Attorney General will require you to try to cover your daughter under your health insurance prior to allowing Medicaid to stay as the primary insurance.
Okay.
So you will have to try to cover your daughter. You'll need this order, and it'll allow you to cover her prior to your enrollment period, because usually they'll do enrollment in the fall.
Yes.
Now it depends. I don't know about the cost, but it can't be more than 9% of your gross income per month. So you'll be required to cover your daughter under your health insurance. Now, what about child support? What is the amount that you all agreed to?
It's already there on the what the Attorney General has.
Okay, so then you're going to continue with the order that's that we consolidated into this case?
Yes, ma'am.
Okay. And Ms. Lopez, you're not asking for a review of that child support at this time?
No.
Okay. Okay, and Ms. Lopez, are you asking for a name change?
Yes.
What is the new last name?
Escalera.
Okay. So you've heard the testimony that Mr. Lopez has placed on the record. Is that your agreement?
Yes, Your Honor.
Okay, the court will also grant your name change, will grant the relief as requested and testified to on the record, and grants this divorce today. I'll ask for the proposed divorce decree that was filed back on January 24th, 2022 to be forwarded to my queue, and I'll make any necessary adjustments on there, okay? All
Yes,
right, so good luck to you all, and I commend you on coming up with an agreement that places your daughter first.
Thank you, Your Honor.
Okay, thank you.
As soon as I sign it, it'll be sent to both of you.
Thank you, Your
Okay,
Honor.
the divorce is final 30 days after I sign the decree, and that's when you're free to marry or whatever it is that you want to do.
Okay. Thank you, Your
Okay,
Honor.
all right.
May we be dismissed?
Yes, you are both dismissed.
Thank you.
Okay, Ms. Saldana, I didn't know if you were waiting to see if somebody came on, or else I would have called you at the beginning. Oh, you're on mute.
Okay, sorry, Judge. I was waiting for somebody to log on apparently, and I was talking to him. He did log on shortly, and he just right a few seconds ago logged off.
Who's representing Mr. Vargas?
He was just served a few days ago, so I'm not sure if he's going to retain counsel or not.
Okay.
I
So
did-
you're asking for the protective order to be extended?
Yeah, unless I can take a default.
Okay, well, he's not here, so he was properly served and you did
Yes.
see him on, so we can move forward, but Ms. Gomez is not here. Were you gonna need her testimony?
It depends on how you want to do that, Judge, or if you, yeah, I know in some courts we're able to dictate it just onto the record, or I can have her appear. It's whichever you prefer.
Okay, you can go ahead and dictate it onto the record. That's fine with me.
Judge, we are asking for a 2-year final protective order with findings. The parties were, or they are divorced. There's no minor children. There's no property to be divided. That was taken care of in the divorce case. But we are asking for the court to grant an order that prohibits the respondent from committing future acts of family violence, from communicating in any manner with the applicant or with a member of her family or household, directly or indirectly communicating any threatening or harassing communications, from going within 200 yards of the applicant 200 yards of her residence and place of employment. And for possessing a firearm. If he does have a firearm, we've asked that he surrender it to the Hidalgo County Sheriff's Office. And if he has a license to carry, that it be suspended. We are asking that the court costs be waived and that this protective order continue in effect for 2 years.
Okay, on P 0044-22-9, the court is taking judicial notice of all the documents in the court's file, specifically that the respondent was properly served and he had not show up, and if he was on, he did not remain on, knowing that we were going to continue with the docket and that the docket has continued. And so the court is granting the relief as requested onto the record by the district attorney's office. And this will be a 2-year final protective order, and it will be granted. Go ahead and get that filed so that I can sign off on it as soon as possible.
Yes, Judge.
Okay, anything else?
I have nothing further, Your Honor.
Okay, thank you, ma'am.
Thank you, Judge.
Have a good day.
You too, Your Honor.
Okay, and looking at the docket, did anybody call in on number 14?
Yes, ma'am.
Okay, go ahead.
Attorney Jose Gonzalez called this morning that he had filed a letter that they were going to be passing the hearing because they are coming to an agreement, and they will either file a motion for a new hearing or they're going to be filing their motion to dismiss.
Okay. And what about number 26?
I don't have anything on that one.
I don't either, Your Honor.
Okay.
That's not like them.
I know. Go ahead and contact them and see what it is that happened, and just give them the next soonest status date if they're still going to continue with the case. Okay, number 30 is reset for 1:30, and so we'll go ahead and resume at that time. Let me go ahead and